Now we change perspective entirely. Every chapter so far has asked what companies may do with data. This one asks what happens when the government wants it. And I'll be honest with you, this is nobody's favorite chapter. It's dense, the acronyms are brutal, and it feels distant from daily practice. It's also thoroughly tested, so let's do it properly. 5 focus areas. First, financial records. The Right to Financial Privacy Act and the Bank Secrecy Act, which pull in opposite directions in a way I find genuinely interesting. Second, electronic communications. ECPA and its 3 parts, the Stored Communications Act and CALEA's design mandate. Third, legal process. Subpoenas, warrants, court orders, wiretaps. Different instruments, different thresholds, and knowing which is exam gold. Fourth, national security. FISA, Section 702, National Security Letters, the PATRIOT Act, and the Freedom Act reforms. And fifth, the civil side. Cybersecurity information sharing, the Privacy Protection Act, and e-discovery obligations. Stay with me. This chapter explains why Schrems happened. Let me show you 2 statutes that contradict each other beautifully. Start with the problem. In 1976, the Supreme Court decided United States versus Miller. It held that you have no Fourth Amendment expectation of privacy in your bank records because you voluntarily gave them to the bank. That's the third-party doctrine, and it's foundational to everything in this chapter. Congress didn't like that outcome, so in 1978 it passed the Right to Financial Privacy Act, creating by statute what the Constitution didn't provide. The RFPA requires that federal agencies seeking your financial records use proper legal process, and generally that you receive notice and an opportunity to challenge it. Notice: federal agencies, not state, not private parties. Now the Bank Secrecy Act, 1970, runs the other way entirely. It requires financial institutions to report currency transaction reports for cash transactions above a threshold, suspicious activity reports when something looks like money laundering or fraud. And here's the part that matters. SARs are secret. You cannot tell the customer. That's tipping off, and it's a crime. The BSA even has a safe harbor protecting institutions from liability for filing. So picture the compliance officer. RFPA says protect the customer's records. BSA says report the customer secretly and never tell them. Which wins? The reporting obligation, every time. So a badge appears at reception asking for customer data. What now? Let me give you the framework I teach every client. First question: what's the legal instrument? A polite request is not compulsion. A subpoena is. A warrant is. A court order is. If someone asks nicely, you may have discretion. If they present valid process, you generally must comply. Second question: is the process valid on its face? Right court, right jurisdiction, properly signed, within scope. You're not the judge, but you can check the basics. Third, what does it actually cover? Overbroad requests happen constantly. If the subpoena asks for all records relating to a customer and you have 12 years of everything, does it really mean everything? Narrowing is legitimate. Fourth, can you notify the customer? Sometimes you must under RFPA. Sometimes you're prohibited under a gag order or a SAR. Sometimes you may, and that's a policy choice. And here's the practical advice I'd give any organization. Have a written law enforcement request policy. Route everything through legal. Train reception staff because that's where the failure happens. I've seen a branch manager hand over records to an officer who simply asked. No process, no documentation. He thought he was helping. That single decision created liability nobody anticipated. ECPA, 1986. And keep that date in mind because it explains everything wrong with it. ECPA has 3 titles. Title 1 is the Wiretap Act, governing real-time interception of communications in transit. High standard. Essentially a super warrant, requiring probable cause plus a showing that other methods have failed. Title 2 is the Stored Communications Act, governing stored communications. And here's where 1986 shows. The SCA distinguishes based on how long a message has been stored and whether it's been opened. Under 180 days and unopened, warrant required. Over 180 days or opened, lesser process suffices, sometimes just a subpoena with notice. Why? Because in 1986, email was downloaded to your computer and deleted from the server. Anything sitting on a server for 6 months was assumed abandoned. Now think about your inbox. 20 years of mail on a server, all of it opened. Under the statute's literal text, most of your email gets less protection than a letter in a drawer. Courts have pushed back, notably in Warshak, requiring warrants for email content. But the statute still reads that way. Title 3 governs pen registers and trap and trace, capturing dialing and routing information rather than content, lower standard. CALEA 1994 is different. It requires telecommunications carriers to build interception capability into their networks. Design mandate, not access authority. Let's line up the instruments because the exam loves this hierarchy. A subpoena is the lowest rung, issued by a prosecutor, a grand jury, or an agency. No judge reviews it beforehand. The standard is relevance, essentially, and it typically reaches non-content records, subscriber information, transaction logs. Next, a court order under 2703D. This requires a judge, and the standard is specific and articulable facts showing reasonable grounds that the records are relevant and material to an ongoing investigation. That's more than relevance, less than probable cause. It reaches transactional records. Then a warrant. Judge issued, probable cause required, particularity required. This is what you need for content under Warshak and for most stored communications now as a practical matter. And at the top, a Title 3 wiretap order. This requires everything a warrant does plus more. Probable cause for a specific enumerated offense. Necessity, meaning you must show other investigative techniques have failed or would be too dangerous. Minimization, meaning agents must stop listening when the conversation isn't relevant. Time limits, periodic reports to the judge, and eventual notice to the target. Do you see the ladder? As the intrusion rises, the requirements rise. And here's the takeaway. When you see a scenario about real-time voice interception, the answer is almost always the highest standard. Content in transit is the most protected thing in American law. Now we enter national security and the rules change fundamentally. FISA 1978 came from the Church Committee investigations which exposed decades of domestic surveillance abuses. Congress created a separate legal track for foreign intelligence with its own court, the FISC. Judges appointed by the Chief Justice, proceedings classified, generally hearing only the government's side. Traditional FISA requires probable cause that the target is a foreign power or an agent of a foreign power, not probable cause of a crime, different standard entirely. Section 702, added by the FISA Amendments Act of 2008, is the big one, and you need to understand its shape. It authorizes targeting non-US persons reasonably believed to be located outside the United States to acquire foreign intelligence. No individual warrant. Instead, the FISC approves annual certifications and procedures. Targeting procedures, minimization procedures, querying procedures. And here's the controversy. Incidental collection. When a foreign target communicates with an American, that American's communications are collected too, and then queried. Critics call it a backdoor search. Section 702 sunsets periodically and gets reauthorized amid fierce debate over querying restrictions. Now, why does any of this matter to you? Because Section 702 is the reason Schrems succeeded. Twice. European courts looked at 702 and said, Europeans have no redress here. That's the whole transfer problem in one statute. National security letters deserve their own slide because they're unusual and troubling. What is an NSL? An administrative subpoena issued by the FBI. No judge, no court approval. A senior FBI official signs it. What can it reach? Non-content records, subscriber information, toll billing records, financial records, credit information, not content. The authorities come from several statutes, including ECPA, the RFPA, and FCRA, and they came with gag orders, historically automatic and indefinite. You received an NSL and could tell no one, not your customer, not the public, not initially even your lawyer, though that was corrected. Think about the position that creates. A company knows the government took its customers' records. It cannot say so. It cannot even say it received one. Courts found the indefinite gags constitutionally problematic. The USA Freedom Act added reforms: periodic review of gag orders, termination procedures, and limited transparency, permitting companies to report NSLs in broad numerical bands. That's why you see transparency reports saying 0 to 499 national security requests. That band is the law, not vagueness. Here's the point I want to land. The scale was enormous. Hundreds of thousands issued over the years with minimal oversight. An administrative letter from an agency with no judge and a permanent gag. That's how far the third-party doctrine can take you. Let's trace the pendulum, because these two statutes are the swing. The PATRIOT Act passed in October 2001, 6 weeks after September 11th. Overwhelming votes, minimal debate. And it did many things. Section 215, the business records provision, is the famous one. It let the government obtain any tangible things relevant to a terrorism investigation from a FISA order. Library records became the symbol, hence the nickname. Section 505 expanded NSL authority. Section 213 authorized sneak and peek warrants, delayed notice searches. Roving wiretaps followed a person rather than a device. And the wall between intelligence and law enforcement came down. Then in 2013, Snowden revealed that Section 215 was being used for bulk collection of American telephone metadata, not targeted records, all of them. And that reading of relevant shocked even the statute's authors. So in 2015, the USA Freedom Act responded. It ended bulk collection under 215. Data stays with the carriers and the government queries with a specific selection term. It created amici curiae at the FISC, so someone argues the other side. It added transparency requirements and NSL gag reforms. Section 215 itself later lapsed in 2020. Here's the lesson. Crisis expands surveillance, revelation contracts it. Then the cycle repeats. Where are we in the cycle right now? Worth thinking about. Let's talk about a genuinely difficult trade-off and one where reasonable people disagree. Here's the problem. Companies detect attacks constantly, indicators of compromise, malicious IP addresses, malware signatures. And sharing that information helps everyone defend faster. So why don't they share? Fear. Antitrust exposure from talking to competitors. Privacy liability from sharing data that might contain personal information. Reputational harm from admitting you were attacked. The Cybersecurity Information Sharing Act of 2015, CISA, addressed this. It authorizes sharing of cyber threat indicators and defensive measures with the federal government and with each other. And it provides liability protection for sharing done according to the Act. Antitrust exemption, exemption from disclosure laws, protection from regulatory use of the shared data. But it requires you to remove personal information not directly related to the threat before sharing. Now the critique, and it's serious. Threat indicators can contain personal data. An IP address is often personal data. Email headers contain addresses. and the sharing channel routes through DHS but can flow to intelligence and law enforcement. Critics called it a surveillance bill wearing a cybersecurity costume. There's also CIA, which mandates incident reporting for critical infrastructure. That's compulsion, not voluntary sharing. So which is it? Defense or surveillance? Honestly, both. That's why it was contentious. Let me tell you the story behind this one, because it's a good one. In 1971, police searched the Stanford Daily, a student newspaper, looking for photographs of a protest. Not because the paper did anything wrong, because it had evidence. The paper sued, and in Zurcher versus Stanford Daily, the Supreme Court said the search was fine. A warrant reaches any place where evidence might be. The press was alarmed. If police can search a newsroom for evidence, confidential sources are worthless. So Congress passed the Privacy Protection Act of 1980. It restricts government searches and seizures of work product and documentary materials held by people intending to disseminate them to the public. Journalists, publishers, and by modern interpretation, potentially bloggers and others. The rule is essentially use a subpoena, not a search warrant. A subpoena lets the recipient object in court first. A warrant lets agents walk in and take. There are exceptions. If the possessor is themselves suspected of a crime related to the materials, imminent danger of death or serious injury, risk of destruction, and it has a private right of action. Here's why this belongs in your mental model. It's a rare American statute protecting the process of holding information, not the information itself. The distinction between subpoena and warrant is the whole point. One gives you a chance to say no. Let's finish this chapter on the civil side. Because private litigants get data too, and that surprises people. The federal rules of civil procedure govern. Rule 26 defines the scope. Discoverable material must be relevant to a claim or defense and proportional to the needs of the case. That proportionality language was added in 2015 precisely to rein in runaway discovery. Rule 34 covers production of electronically stored information. Rule 37E addresses failure to preserve ESI, and it's the sanctions provision. Now the litigation hold. When litigation is reasonably anticipated, and that's earlier than filing, you must suspend routine deletion. Issue the hold, identify custodians, preserve. And here's the collision I want you to feel. Your privacy program says minimize, delete, retain only what's needed. Your litigation obligation says freeze everything possibly relevant indefinitely. Which wins? Preservation, always. Because spoliation sanctions are severe, up to adverse inference instructions or default judgment. Privilege matters too. Attorney-client privilege protects legal advice. Work product protects litigation preparation. And in breach response, this is why forensic firms are often retained by outside counsel rather than the company directly. Does that work? Sometimes. Courts have pierced it where the report served business purposes too. So here's the practical point. Privacy and litigation are permanently in tension. Manage it. Don't pretend it's solved.